Got all the cameras on? Okay.
You ready to kick it off?
Yeah, your show. Go ahead.
Yeah, absolutely. So obviously we're here for impact bargaining. I guess the two kind of primary and over-encompassing issues would be body-worn cameras, as well as we have some changes to the use of force policy. All this was obviously outlined in the letter that was sent from my office, going over some of the issues. I like to do it with written proposals. It's just, I think it's easier. I think we can kind of follow.
Sure.
So I'll kind of give you copies of what we're talking about today.
Okay.
Obviously, you know, the onus of really why we're talking about it is because of the incorporation of discipline as it relates to the body-worn cameras. And so, you know, the intent here is to kind of, there's some issues we want to flush out, some things we want to talk about, see how things are going to apply. There's also been some changes to the policy that I kind of address, and we'll kind of go over, you know, how we feel about those. And, you know, we have some proposals to change or alter, maybe rescind or go back the way some things were, but all of them, you know, are kind of based on one kind of general idea. So to kind of get that started, I'll give you some copies of what we're looking at. I think I made more copies than you need, but we have to our guys as well. So it's not down there. And the rest are for you. I make reference to the actual policy in here. I'm assuming that you have it. I didn't provide copies of it. It's 13 pages long. But if you don't, you know, I can kind of go over what we're talking about and how the policy was changed and then what we're talking about. So I guess the first thing to discuss would be, you know, there was a change that incorporated policy 26.2, 155, 156, and 157.
So we're on the body-worn camera, okay?
We're on body-worn cameras, that's correct. I separate the use of force, and I'll tell you why.
No, that's fine. Actually, it's a lot easier
Yeah.
to do it that way, so.
Well, and use of force is going to be a little bit more difficult to discuss, and the good thing is, and I understand this is how it's been done in the past, is that the body-worn camera policy changes were actually in legislative format. That way we can actually see what's going on and what's changed. The use of force policies were not, so it makes it a lot more difficult for us to talk about specific provisions.
Okay.
So, you know, as that goes, it'll be a little bit more difficult. So I think if we bifurcate the issues, I think body-worn cameras are probably going to take up a little bit more time anyway, and hopefully we get through all of that today. I'm hoping we do, but the other one I think is going to be a little more.
So we're working off of 41.20,
41.20.
the 10/17 effective date version. I think that's just a clean version of the 3/17.
Okay, the one we have is from the 3/17.
Okay.
So I'm assuming it's the same.
Yeah, it is. So I'll go off of the 3/17.
The March 3rd version has a, you know, essentially a cover page, which kind of talks, you know, about the changes. And this is where it actually makes reference to the 26.2, which is standards of conduct. So we have some new issues there. So essentially what we're doing there is we created, or you guys created the multi-tier disciplinary system with violation subject up to 1 day, violation subject up to 5 days, and violation subject to dismissal, depending on the type of violation that you're talking about. And so that's kind of where we propose to start. You know, obviously, whenever you incorporate discipline into these, I think, you know, we have the primary issue that, you know, with a policy this long and extensive, you know, the potential for there to be violations, I think, is increasing. The longer the policy is and the more specific it is, you know, the more chance there is for a violation. So obviously, the fact that discipline is being attached to it is a primary issue of concern, but I think most importantly, when we're talking about up to including dismissal. And so if you look at the proposals that I submitted, we go over that one first. And so we actually have a proposal to change the language in 26.2.157 to read essentially as I laid out in legislative format. To follow, if you're not familiar with legislative format.
No, yeah, I've heard of it. I'm a little bit lost here. So paragraph 1?
No, it's actually, it should look like this.
Okay.
I don't know if you have copies of it or not.
Are you talking about the sheriff's March 3, 2017?
That's correct, yep.
No?
Yeah.
Okay.
Do you have a copy of it?
Yeah, there's one right
Looks like this?
Yeah.
Yeah.
Okay, I got that. So,
So the first part we're referencing is at 26.2.157.
okay, so paragraph 1 on what you just gave me is,
Mm-hmm.
got it.
So it currently reads, any employee found to engage in purposeful acts with the intent to defeat the purpose of the BWC in order to avoid or manipulate the recording of events while on duty will be subject to disciplinary action up to dismissal. So we have some changes in there. And the intent really behind our changes is that it's a little too broad. I think it could be left open to interpretation for an investigator, you know, as far as intent to defeat the purpose. I think really, and you can correct me if I'm wrong, the idea here is, you know, up to including dismissal obviously is a severe violation. And so I think the idea and what we're trying to, you know, point out here is that we're talking about unlawful activity. We're talking about someone trying to turn off the camera in order to avoid them doing something nefarious. And so that's our intent behind that language. So ours reads, any employee found to engage in purposeful acts with the intent to defeat the purpose of the BWC in order to engage in unlawful activity while on duty, and we struck shall and included may be subject to disciplinary action up to dismissal.
So does that mean that if I'm wearing a body-worn camera and I turn it off for the purpose of not recording a violation of policy that doesn't rise to the level of a violation of law, then that's okay?
Well, I mean, we're talking about as it relates to up to discipline for dismissal. If we're talking about that, then you're saying it up to, you know, 5 days suspension, I think is what it would fall.
How do you know what it's gonna be without knowing what the misconduct is?
Well, I mean, that's
I
part,
mean,
that's on the
doesn't-
investigator.
Up to doesn't mean that it's going to be. Up to can be a verbal warning.
Sure.
It could be a written reprimand, just
Sure.
because you put it up to a certain level.
Yeah.
And how do you turn around and say that, you know, we're gonna go into this thing not knowing what the level, not knowing the nature of the misconduct, and say, we're going to place an artificial limit on what it's gonna be? What happens if this is a repeat offense? This is the second or third time that the person's done it?
That's not addressed in this policy at all, so I mean, we're talking about what ifs that aren't even here,
Well,
but, you
that's
know.
addressed in discipline and taking disciplinary
Sure,
action.
it's up to IA to determine that. So it's up to IA to determine if what they're looking for, and that's what we're saying.
Well,
It's,
does IA determine level of discipline?
It gets recommended to me at the end of the day, I determine what.
Okay, but so when but your IA officers actually recommend a level of discipline? Okay, not every agency does it that way.
sure, but I mean, IA is also going to go through and look at what, if they're gonna say you intentionally turned off the camera, part of what the investigation is gonna be, why did you intend to turn off the
Of
camera?
course.
So, and it really is what happened, what did it miss? What are you claiming that it missed? And I think with that, that's what we're talking about, we're talking about the highest level of discipline. I mean, the sheriff's office actually created a tier system, we're just trying to make it a little bit more specific.
Sure, I understand, but the thing is that, my point is that there are some reasons that you can turn off that camera that aren't unlawful, but that are still serious violations of Sheriff's Department and county policy.
Well, if you
And I
look
don't
at-
understand why we would artificially limit it to say that under no circumstance can somebody be disciplined if they turn it off for a reason that's not unlawful.
Well, why we're here is to negotiate it. So if you think that language is too stringent, I'm happy to listen to a counter proposal as it relates to that language.
Yep.
So, would you like to offer that now, or would you like me to continue?
No, I might as well go through all of this, and then I kind of like an opportunity to consult with my folks. And
Sure.
usually, while I raise questions and may, you know, even argue a little bit here and there regarding some of these points, at the end of the day, you know, it's gonna be these folks that are gonna decide what they believe is
Sure.
the best interest of the department, the officers, and the public.
Well, I'm not gonna be offended, so,
Okay.
you know, I
You don't seem easily offended, so
I
that's
don't,
fine.
I don't, and you know what, I kind of run negotiations, you know, this is obviously our first time together.
Yeah.
But, you know, I like to kind of have an open dialogue.
Sure.
So, you know, if anybody has questions, you know, feel free to ask, and we can kind of work through that as well. So, you know, we're really, I think, you know, and I can preface this by saying, I don't think we should be adversarial as it relates to this. I think that the idea, you know, should be the same, is that, you know, this policy is meant to protect the public, but there also needs to be safeguards that relate to deputies. You know, I mean, that just because they put a badge on doesn't mean they give up all their rights.
Sure.
So, you know, that's why we're here. So, you know, working with that framework is absolutely what we're here to do. You know, we're not here to be a hindrance, we're here to work with you guys on something that's mutually beneficial for everybody. So, you know, with that being said, you know, hopefully we can continue to do that.
So paragraph number 2, the policy section, is that now going to the?
That jumps to the next page, that's right.
Okay.
So that's actually the first page, is gonna be page 1 of the actual policy. And you'll see it has subheadings, so we have purpose, policy, discussion, excuse me, definitions on that first page. This falls within policy. And so the very last paragraph is added, where it starts, in accordance with. That section is brand new.
Right. Got it.
So the issue that we have here is the language seems a little strong, first and foremost, and secondly, it doesn't really allow for any discretion. I think, you know, discretion is well, in this context, is a management right as well. And I don't think that the intent here was to eliminate, you know, the sheriff's office or your supervisor's ability to have discretion as well. You can correct me if I'm wrong, but you know, obviously shall to may is very important language when we're talking about legally. So you can kind of read the way it was before, but you know, we had a couple of small changes. The intent is, from what we understand, for this last paragraph, is essentially that a supervisor is going to be held liable for the actions of a subordinate, which obviously to a degree is reasonable. The way that it's written, however, to quote it, supervisors shall be held strictly accountable and subject to disciplinary action for failure on a subordinate's part to adhere to this policy. And so in practicality, you know, in discussing this, you know, if you have a supervisor who has no clue or has no reasonable ability to have overview of everything that he does in relation to that policy, you're gonna, and again, we have shall here, so you're saying that a supervisor is going to be disciplined because of something that he may not have, you know, a reasonable opportunity to oversight.
I understand.
So our language obviously eliminates that, or not eliminates it, but it lessens it to a degree.
No, I understand.
So the way ours would read would be in accordance with Directive 26.2, Standard of Conduct, any violation of this policy/directive may, switch from shall, result in discipline, took out up to including termination. The reason for that is obviously there's different tiers, so, you know, I don't think it's necessary unless we want to talk about all 3 tiers. I think result in discipline, I think is sufficient. Then it says supervisors shall be held, and I struck strictly accountable, and may be subject to disciplinary action, excuse me, for, and I insert a foreseeable failure on the subordinate's part to adhere to this policy. Make sense?
Makes sense.
Okay.
Where do I find the buffering mode?
Buffering mode is going to be on page 2,
Okay.
41.20.2A.
Okay, so that was something that wasn't changed from Sheriff Johnson's policy.
It was not changed, however, the way we understand is that the new cameras that have been ordered have a different ability than the original ones. So the original cameras, as far as we understand it, only had the ability to record video in the buffering mode and no more than 30 seconds of it. I can tell you this is probably one of the bigger issues that we've been discussing. The new cameras supposedly have the ability to record 1 minute and 30 seconds of both video and audio. Now this is, again, as far as we understand, customizable by the sheriff's office. And with that being said, what we're essentially asking for is status quo as it relates to the understanding of the original devices in this first part as far as our proposal. And I can give you countless examples of how this could be a potential issue.
Well, yeah, actually, do it.
Huh?
Yeah, no, I mean, that would be helpful.
Yeah.
What is the,
No,
what's the what's the issue with buffering?
One of the ones that was addressed in the letter, and I think is something that definitely holds true. I mean, what happens if a deputy's using the restroom, and then as soon as they exit the restroom, something happens, camera goes on. You're gonna catch 1 minute and 30 seconds of the deputy in the restroom? I mean, that's first and foremost.
Okay, well, let's just stop there for a second, because presumably the camera goes on because something that was important enough to capture happens on
Sure.
that. And so, okay, what is the issue with the fact that it recorded that 1.5 minutes of the person in the bathroom?
Well, I mean,
It's not gonna be part of the evidence in the case, or?
It's gonna be part of public record.
No, it's not.
No.
How is
That
it
would
not?
not be released. That
Okay.
could be released by public record.
Okay, well, part of the second part of what we're talking about is essentially a guarantee, or not a guarantee, but a way for deputies to ensure that's the case. I mean, listen, that, issues happen. I mean, you know, people who are doing this redacting are not perfect, there's no perfect person out there, so there's a possibility it could be released. So, you know, the idea is that if we're running 1 minute and 30 with all this information, and again, this is just one example, I mean, what happens if a call happens again where, you know, something happens, but right before the deputy is on the phone talking to their significant other about a very private situation. Again, something happens, camera gets turned on, you know, it's now part of public record. Again, it's gonna be on the sheriff's office to go through and redact that information, I don't know if they would, that's part
It
of what
would
we're
be
here for.
redacted.
Okay,
Anything of personal nature would be redacted.
okay, and again, that's part of the concern.
Because I would think that there are times that having that 1.5 minutes of buffering
It's going to benefit the
is
deputy.
gonna benefit the deputy, benefit
Sure,
everybody.
I mean, that's what it's there
Because,
for.
you know, because it seems to me like it's a balancing issue. I'm sure, yeah, there could potentially be times where there's gonna be something on there for that 1.5 minutes.
I think the
that you
biggest,
would-
I think the
wouldn't wanna
biggest
see.
concern of the deputies
Yeah.
is the audio. So they can't stand around and talk to each other with a camera on their shoulder in a buffering mode, and then all of a sudden now they've gotta turn the camera on, and it's caught the last 1.5 minutes of the conversation they were having, whatever it might be. So that's their big concern here.
That's not what we're trying to do. What we're trying to do is that 1.5 minutes, if he jumps out of the car and he's chasing somebody, damn it, it turn on and he hits it, it catches the 1.5 minutes of the car chase. That's the important part. If me and you were talking about who's gonna win the Super Bowl, that's not out for public consumption.
Well, you say it's not out for public consumption, but where's there an exemption that says that a deputy having a conversation with another deputy is not public record?
In the 30 seconds, as long as you've had these cameras, has anything not appeared publicly that has not been?
They don't catch
We don't-
audio.
It doesn't catch audio, but it catches video.
We don't have a problem with the video, we have a problem with the audio.
Mhm.
That's what the issue here is that the deputies are concerned that any conversation they're having when the thing has not been activated intentionally now goes back 1.5 minutes to catch whatever conversation they were having.
Well, and we definitely appreciate, you know, what you're saying, Sheriff, as far as, you know, personal information is not gonna be released, but, you know, in order for the sheriff's office to not provide something as part of a public records request, there has to be a legal exemption for it. And not everything is gonna fall under a legal exemption. You know, again, talking about a personal issue with your wife, I don't know if there's a legal exemption under public records law for that. So, puts the sheriff's office in a predicament where you obviously don't wanna release it, we don't wanna release it either, but legally you may have to. So, you know, again, I think the audio portion is really what we're talking about as far as an issue of concern. The second part of my proposal as well, which again gives the deputy the ability to kind of review anything that is being requested, is another part of it as well. Again, it's peace of mind. And listen, we completely understand what you're saying, because as I've gone through this policy, you know, ad nauseum, you know, I see that there are a lot of instances where we do talk about, you know, as safely as possible, because there's gonna be opportunities where you can't turn the camera on right away. You know, you're running, you're fighting with somebody, you're doing something, and, you know, maybe there's some information that could be useful. But I think that proper safeguards are really kind of what we're looking at.
Okay, we'll take it.
Is there any other examples or anything you want to talk about before we move on? I know this is a big issue for us.
No, we're good.
Okay.
Put the videos
All right, so the next one is 41.20.13. That's going to be on page 3. This section was deleted. I guess the first thing we would pose is a question as to why. I mean, we don't see why this would be deleted. I don't see there any actual need for it to be deleted.
My take on it, and, well, you all probably know better, is that when I looked at this, I thought it was taken out because it's addressed in the last sentence of 41.2012. Deputy shall activate the body-worn camera if doing so does not place them or others in danger.
I mean, I don't think it's, I wouldn't consider it redundant. I would think it, you know, having that extra piece of protection in, I think is important. Again, I think this particular,
What's that?
I got the wrong policy here for some reason. So what you guys are talking about, it's on the first one.
This is what we're talking about, this is the change that was made here. Where we,
and I can read it so everyone understands, the former provision read, if immediate activation of the BWC is not feasible due to an immediate risk to the safety of the deputy or others, the deputy will activate the BWC at the first available opportunity after the immediate threat is addressed. And again, I don't think it's redundant first and foremost, and secondly, if you go through the other changes, as we will as we move forward, there seems to be an elimination of terminology that essentially says, you know, as safely as possible. It seems to be like a continuing theme. And again, the reason why I asked for that is because it seems to me, and please correct me if I'm wrong, that there seems to be a desire or a shift to make sure that everything is captured no matter what, and not taking into account that there are going to be situations where the safety of the deputy is more important than
Give me an
turning it on.
example of when you would be in danger of turning your camera on. Well, give me a scenario. If you get a radio call,
Sure.
and you activate that call while the car's moving, all you do is push the button.
Well, I mean, the radio call is one, this says if immediate activation of the BWC is not feasible. So what we're talking about is fighting with somebody. We're talking
Then
about.
you had to get the fight with him prior to, right? You just don't step out of the car and start fighting with somebody.
Well,
You're going somewhere. You
could.
do it. Give me an example when, in 31 years, there has never been a buffer when I was a cop, that I didn't start fighting with somebody, where I just opened the car door and was fighting.
Well, I mean, if you're talking about every single citizen, and that's part of the other part of the policy, is that every single citizen encounter is essentially being asked to be recorded. I mean, we're of the opinion that every single citizen encounter doesn't have to be recorded. I think it's not necessarily, it's not necessarily a good thing to be recording every single person at every time.
Why?
Why? Well, because, you know, I think the policy actually kind of lays it out, and now we're kind of changing it, but the policy has a lot of different reasons why. I think, you know, some people are uncomfortable with cameras. I think that,
And is there, I'm not to interrupt you, I'm sorry, but isn't there a provision in there that says if the victim does not want to be recorded, you're allowed
you have
shut
to
that
ask
down?
them. I mean, a lot of people aren't gonna say, you know, it's also not particularly practical to walk up to somebody who's a victim and say, by the way, I'm recording you. If you don't wanna talk to me now, you have to talk to me. You know, that's not how police work is done. I mean, you go up, you try and talk to somebody, you try to create a rapport with somebody. I mean, the first thing you have to do is tell them, by the way, I'm recording you. You want to talk to me, you have to tell me you don't want to talk to me, and then I got to turn my camera off. So a lot of it's practicality too. You know, and again, some people just, they don't want to. I mean, you want to get out, and I mean, part of this is community policing as well. You want to be able to get out and talk to people about the game, about, you know, how's your family doing, all that stuff. And if you have to every time get out, and by the way, I'm recording you, how's your family doing today? I mean, it's just not particularly practical. So in that situation, if we're saying that it's not turned on all the time, sometimes those situations can turn into, hey, what's going on? How are you doing? I see you hanging out here by the park, you know, and then all of a sudden, we didn't know this person has a warrant, fight's on.
then you definitely need that
Do we,
minute and a half.
do we have
Sure.
to give a warning to tell people we're recording when you have consensual conduct with them, when you have a consensual encounter?
That's how the new
There
policy
are
reads.
exemptions in there for it, yeah.
Yeah, that's how the new policy reads.
Let me use myself as an example, Sheriff. I'm at the airport, somebody comes off a plane, they say, hey, where's baggage claim? Hold on a second, let me turn this on. Sir, you need to understand that I'm recording you now. Are you okay with that? Baggage claim is down the escalator. Is that really the intent of the body worn
It's
camera
not, but
policy?
where did that come from? Where's that coming from?
I think that was pre-existing before we got here, Sheriff Johnson.
No, there was an addition into the policy, that mandates that we have to tell people, that we're recording them.
What section is it from?
I'm looking for it, hang on one second.
41.257
Yep.
and 58.
41, say that again, 41?
41, 20, 57.
Under demonstrations?
No, you're looking at the wrong one again.
I got it.
41, 20, 57.
Sure.
Thank you, sir. You're welcome.
What is that? You gonna read it for the record?
Sure. Hold on, let me catch up here.
It's on page 8. Page 8.
Oh, okay. That's easier. Yeah, all right. 41.157.
Okay.
When the deputy identifies a person as a victim of a crime through an on-scene investigation, the deputy with the BWC is still activated and must on video notify the victim that he/she is equipped with the BWC and that is recording. The deputy shall then request consent to continue recording the victim. If the victim requests to not be recorded, the deputy shall, while still on video, state the date and time allowed and indicate that the BWC shall be deactivated for such purpose. The entire procedure shall be recorded on the video and noted in the deputy's report or CAD if no report is completed.
And what did you say you want to change this to?
Well, wait, has
Yeah,
it,
that's-
that hasn't
that's what he
applied,
said.
has applied to the.
And there's another one, actually.
Okay.
That's one example, but there are ones, we're kind of jumping ahead. I did everything in order. So the first part, if we go to 41.20.50, where it says enforcement-related contacts, essentially this is every time that the camera has to be activated. And then there's a list, starting with A and going down to K. F says any citizen contact.
Okay.
So I mean, that's the first part, and that's, again, something that we were going to address before, and part of this is clarification. I mean, are we talking about any citizen contact?
So that's,
Right.
so but that's part of the old policy.
No, that's new.
No, that
Or
was
is that
new.
part of the new policy? Yeah. On seven.
Any citizen contact was added. In the
Yeah.
old policy, if somebody walked up to you and said, hey, can you give me directions? We didn't have to activate a camera. Under the new policy, it's anything. I mean, and that's where I think it's a little problematic in the sense that directions to the restroom would have to be recorded.
I got
And
you.
I don't think that's the intent,
I got you.
but
There's also, is it, 5.9? We'll kind of go through it, but again, I mean, there's been a concerted change to essentially, and again, part of it, why we're here is to kind of clarify this. It's a concerted change to say that every citizen contact has to be recorded no matter what. And I think, the old policy took into account for specific exemptions based on, practicalities of doing the job. And I think that the idea here is, we'd like to see those exemptions be outlined and reinstated. Again, because, it's more of a concern when you start activating, or attaching discipline to it. Someone makes a mistake because they didn't realize that they do have to record someone asking them for directions, okay. Before it would be, hey, by the way, read the policy, make sure it happens. Now it's, by the way, you're gonna get a suspension, maybe up to 5 days, or maybe dismissal, because if they say that was intentional, but you didn't do it, well, now you're fired for that. And again, that's why we're here, and that's why this is so important.
Okay. What's the issue with respect to 41/2016?
41.2016, which is on page 4. This policy outlines, and which was negotiated prior, that deputies would have the ability to wear the body-mounted cameras on their collar. It is our understanding now that all of the body-worn cameras are purchased and do not have the ability to be worn in the collar, or not being allowed to be worn in the collar.
Not necessarily true.
Okay.
Right now, we are T&Eing the head mounts, and there's a new collar that's coming in as well.
Okay.
To figure it out, because what happens is, when the deputy gets involved in a foot chase or whatever, and it's on the shoulder, we get really good shots of people's shoes.
Sure.
Depending on your height, you get really good shots of something else.
Well, part of the problem though right now is you're issuing cameras that don't have the options that we negotiated. So you're issuing cameras that aren't giving the deputies the ability to wear it on their collar. And that's where we run into a problem. Guys don't want to wear stuff on their head. That's why we negotiated the ability to put it in there. And when we ask the question, the person issuing the camera, we're told, no, that option is no longer available. You can't have it.
Yeah, he misspoke, because he went back to Taser, and jumped in here wrong, and talked about, it was the new generation of collar mounts and the head mounts.
Right, all that's coming in. Or
Okay.
it should be, some of it should be on the field. I think we're looking at FTOs first.
Okay, well, I guess one of my thoughts, Chief, is the people that are getting these new cameras that don't have the option, the old cameras, everybody has the collar mounted option. To replace theirs with the new style is great, but the guys that are getting the new cameras that aren't being given that should probably be given that stuff immediately, so that they have that option. And then likewise, apparently there's some direction that has been put out by email at some point that it was no longer acceptable to wear the device on your collar, that it had to be head mounted either by ball cap, glasses, or that band around your head. So I think we probably need to get that clarified, that the collar mount is still an acceptable mount.
And Sheriff, you said that you're actually testing some new mounts, or?
Yeah, there's a new generation of head mounts, and there's a new generation of a collar mount.
Okay.
So we asked IT to order those things and put them out there and see what they're doing.
Was there also, I think there was, I was talking to some people as well, there might be ones that are actually mounted.
That's gonna be for K-9.
Okay.
Because K-9, I mean, those guys are tracking through woods and everything else, and the stuff gets just ripped right off of them.
Have
And
you
if
looked
look
into that as an alternative for deputies as well?
I have in my previous life, and when you go to put your gun out in front,
Mhm.
blocks everything you're trying to see. Point of view is the best way to go, is what we discovered with our studies.
Okay.
Sure, just to throw out there, and one of the common things I hear now with the new body mount ones is that the range of video is much better than the old versions. And what I keep hearing from a lot of the deputies is that, God, if they would go to those, you never hear me complain about a camera again, because it's one unit, there's no running wires through your vest and out your shirt here or there, so.
I'll look at it, because like I said, how many we buy for K-9?
I think
Yeah, so.
If you look, we obviously have proposed language, but, we're always open to, additional discussions, especially if we're talking about, the purchase of them or timelines as it relates to that, if we're talking about additional ones. But as it relates to my language, you can see it right there in number 5, which essentially is just, ensuring that guys have the ability to utilize this policy as it's written. So, if you have any questions about that, just let me know.
Just for clarification, when we go back out to the districts, are we, if we have a guy that's wearing it on the collar mount right now, is that acceptable still?
That's acceptable right now,
Okay.
while we're T&E and all this stuff. Ideally, I like to get away from the shoulder, is what I want to get away from.
No, I understand,
But the collar and the head,
but we have some guys that are kind of begrudgingly wearing it because there was some emails that came out that said, you will only wear it on your head, and the email being considered an order, they don't want to risk insubordination, so I just wanted to clarify.
The only.
we'll fix that today.
And the only, just so we're clear, the only people that were permitted to wear it on the shoulder itself were those that were wearing exterior body armor. So it only affected a small few. That was the only people that were authorized under the previous administration to wear it there. It's always been collar mount, glasses, headband, and those were their 3 options.
Yeah, because it says here the epaulette mount while wearing external vest.
Yeah.
Yeah, which is new, that's an
Which
addition.
really affected more K-9 guys and the crime suppression teams that wore that type of a uniform where they wore the vest on the outside.
Do you have a time period of when these new mounts are gonna be coming in, so we can, or is that something you can address?
They've been ordered, I think they could come in any day now.
Okay.
They were ordered a while ago, I know that, a while back.
If you guys are planning on doing some sort of memo, I think that addressing
We'll
that
do,
might be
we'll do an
good as well.
email to rectify what Sarge just brought up.
Yeah,
To get that out there, we'll do that today.
Okay.
We'll get out of here.
very good. Just wanted to make a note, there was an entire new section added beginning at 41.20.39. Starts on page 5 as it relates to spare DWCs. We went through this, and I think that, we don't have any particular objections about this. Obviously recognizing that, with the, discipline being attached to this, there's still some issues there, but I think that, this is, something that's obviously gonna be necessary, and, we looked through it and didn't have any particular objections, so we wanna make a note of that as well. The next one we're talking about is going to be 41.20.47. That is on page 6. This is what I was talking about earlier when I said there seems to be some sort of, concerted movement towards taking out whenever safely possible. This is another situation in conjunction with the original one, which I don't understand the point to take this out. I think whenever you have these types of exceptions, and general prerequisites, I think that I think they're important, I think they're necessary. So again, I don't know why this was taken out, I don't see any particular need for it. Our proposal would be to put it back in.
I want to follow something up, and you asked a question, Sheriff, a few minutes ago, and I'm sitting here trying to, a little off guard with the question, but you talked about when would there be a case where you weren't already actively rolling? And I'll give you an example of one that just comes to mind from the other day, where the guy, out of the blue, slams into the car of the FHP trooper intentionally. Trooper wasn't engaged in other than sitting on the side of the road running radar, and now he's got a crazed lunatic slamming into his car at whatever speed it is, and he's dazed, trying to figure out what's going on. There's a threat now to deal with. He may not have thought to hit the camera right away. He's probably more focused on, okay, what just happened? And I think that's, you asked for an example, and I give you something.
But in the real world, the sergeant.
That was the real world.
In the real world, the sergeant is gonna send a memo or do whatever in the policy and say, hey, based on this, that's why the camera wasn't activated, and that's not gonna go anywhere. That's what's really gonna happen. Because when the sergeant sends something up to me and says, hey, this is why this didn't happen, and it's logical, nothing happens out of it. Just like we had an incident with the sergeant who says, I'm gonna call the attorney, and the attorney says, turn off the camera, because it's a client-attorney
Well,
privilege.
keep in mind, wait a second here, just keep in mind is that there is a provision here that addresses those odd situations. And 41.20.47 talks about and identifies those situations where you're required to, but otherwise are unable to, conditions make it unsafe or impossible to activate the camera. So the thing is that there is a provision in here that addresses some of that already.
Well, I mean, again, I think it's important to have these general prerequisites to say that, yeah, I mean, it's 41.20.47 and then subsequently are telling you when you have to turn it on. And I think to say that, yes, you have to turn it on, but again, there are opportunities, and Sheriff, you're making the point I think that we're making as well. I think we're making the same.
Right,
The same
I don't know
point.
how you would word it, but it's like,
Yeah.
a simple supervisor report, you normally will determine, hey, this is what happened. I
But-
gave Roby's example was.
But the thing is that my point is that, and I understand what you're saying with respect to taking this language out, but, with respect to whenever safely possible, I mean, there is a provision in the policy already, which has an exception for not turning it on when conditions make it unsafe or impossible to activate the
Which
camera.
one are you referring to?
So there should be no reason why we can't leave it in there.
41.20.47A. I'm just saying because And I'm,
Sure.
somebody, look, somebody that hasn't looked at this policy, listening to this would say, whoa, sheriff's department's taking out, everywhere it says unsafe to operate the camera, that's being taken out of the policy. And the thing is, that's not the case.
But that verbiage isn't in .49.
It applies to the whole, it applies to any circumstance
If
in
it's
which you're
in-
turning on the policy.
I think you're right. If it's in 47, I think it applies to all of them. But if we're talking about 48 is its own self-contained provision, which talks about emergency response. I think 49 is its own self-contained provision, that talks about non-emergency response.
I see, I read it as 41, 20, 47 applies to any situation in which the camera is supposed to be turned on.
I think you're right, I think 47 does, and that's why we need that prerequisite. Because each one doesn't have, and as you pointed out, 48 does have that language, 49 doesn't, 50 doesn't, 51 doesn't.
Right, so having it in one place and not having it everywhere implies that it only goes there.
Correct.
However, if you take it out there and you just have it in a one catch-all that applies to every section, then there's no argument that it doesn't apply to every section.
Sure, and I think, and again, I think maybe
Yeah.
we're going around and around,
Yeah.
but I think that's what 47 does, that's our intent.
So suppose you just move that into the policy section, into the very front part of the policy, the very, very front page, as your catch-all.
And it is
Right,
actually,
but we
but
don't
it was,
put, but we
it
don't
was
put all the
deleted.
other, but we don't put all the other catch-alls in each section either.
Right, what I'm saying is, right, you just put it in the opening, so everybody sees it in the opening.
Well, and that was our objection with 41.20.13, is that it was our intention or our understanding that that did create that overall encompassing issue, but now it's been deleted. Hence why we would be requesting that it gets put back in.
I guess we can move that whole section to 1.3. Kind of what you were saying, moving it up front, so this way it's clear that it applies to everything.
I mean,
And then we don't have to repeat it everywhere.
wherever it ends up being,
Yeah.
it doesn't, I don't know,
I,
necessarily matters.
I don't think we're,
Listen, I think
we're in this, I don't think we're really in disagreement here.
No, I don't think we are either. I think at the end of the day, what
Yeah.
we're looking for is basically to be able to say, listen, we all understand that there's gonna be times when
Right.
it's not feasible,
Yeah.
and we recognize those,
Yeah.
and it covers this whole policy.
Sure.
Mhm.
Yeah, I mean, just like we're saying in here, we recognize there's times that it may malfunction, and you're not gonna get dinged for, because it malfunctioned, and, these other circumstances on failure to record.
Sure.
Emergency call out where you don't have immediate access to the body worn camera. And so you're not gonna get thumped for that.
The next one that we're talking about. I think we actually already talked about 50. No, that's where we're at now. Oh, I'm sorry, I jumped ahead. So 41.20.48. This is a question that we have as to why after was struck and upon is being put in there. I don't understand the change. It appears to be substantive, but I don't know if it is.
I think the easiest thing is, once you get the call, we're asking you to turn the camera on once you get the call. Delta 10, you're going to whatever, and just activate it when you're there.
I guess it was probably to avoid maybe somebody turning around, and I know nobody around here nobody here would do it, but, some wise person turning around and saying, well, I turned it on afterwards, it's a half hour after, but it says after.
Sure. Well, so I mean, and, again, my question relates, I guess, to clarification.
Yeah.
So it's your position then that it's still after, but you're talking about essentially as soon as
Immediately
possible.
after.
Yeah, as soon as you,
Right.
right.
As soon as you can hit that button.
Right. And the reason is the overwhelming majority of car crashes in the intersection aren't our fault, and the camera shows that, but yet we pay money out.
Mhm.
It's not our fault, there's those cameras, when you turn it on, you're going, we're lights and sirens, our guys stop at an intersection, they wait for the intersection to go, they go, somebody doesn't see it, and then all of a sudden, it's, oh, the deputy ran the light or whatever, well, that camera takes it on, rates, it's not even that out of 100.
Okay. I think that clarification is what
No,
we're looking for there.
that's really it. I mean,
Okay.
we'll do that.
So the next one is 41.20.50. And again, we talked about this earlier, about some of the additions So the first one that we had is traffic enforcement. And so again, we had a question as to applicability here. Are you applying that if someone is out actually doing radar, are they doing traffic enforcement? So meaning they have to have the camera on while they're doing it before they go after anyone?
Traffic stops.
Just traffic stops?
Traffic stops.
Traffic stops is
Well, but the
covered.
thing is, we have traffic stops, and then we added traffic
I don't know what
enforcement.
traffic enforcement is. John?
I don't know.
Okay. Okay.
We're just,
Good point.
we're trying to make sure our motor guys that are sitting on the side of the road aren't running
Right.
hours of camera.
Hours and hours of
Yeah,
video.
it's just traffic stop.
Okay.
DUI checkpoint, is that traffic enforcement?
DUI checkpoint would be traffic enforcement, but we don't do them. And
Oh, okay, then,
it would be more, the camera would go on once you stop the guy, I think.
okay.
Um,
And then we already covered citizen contact,
yeah.
then building alarms.
Well, so, and just so we can clarify, probably like to have a little bit more of a discussion about any citizen contact. So, does any citizen contact mean literally any citizen contact, or
No,
we have?
we're going to go back and talk about that.
Yeah, we need to talk about
We need
that.
to talk about that.
Okay, okay.
Just a thought I had too, as we talk about that. I see we carved out a section in here, and I think we're gonna come up to that,
We are.
where it talks about school resource deputies, y'all put a specific section there. I think when we get into some of these specialized places that we're starting to put cameras, and I'll use the airport just because I know what's going on there. There are certain times in the airport, like areas that are security-sensitive areas that, like the TSA, they have indicated to us, do not record the monitors on our x-ray machines. But if I turn my camera off, now I'm in violation of the policy. So we may need to carve out a section for issues that come up at the airport.
Or a long-term solution, what we want to do in the future is have a standard SOP for each specialized unit and have that carved out within there.
No,
And then going back to your point about the citizen contacts, I think we just need to just clean that language up. Just, that's listed under enforcement-related contacts, citizen contact, and I think we could definitely talk about that.
And I think, Brody was probably going to get to this as well, but the other part that we had a question about was building alarms. And, Brody, you can kind of explain the scenario.
The airport, again, we get hundreds of what's called door alarms out there. Somebody went through a door, didn't catch properly. Is it the intent that that's something you want recorded? I mean, they're already,
No.
all of those alarms are, every door in the airport's recorded with video already.
My intent is, we got a deputy, 2:00 in the morning, he's alone checking a building, that camera's on for him, God forbid, should something happen, that's what the intent of the building
Okay.
alarms is, I mean.
Okay, good. Brody talked about for my section 10, which is airport encounters. I think that's a good option to be able to address each particular specialty unit as it relates to what they can and can't do or should and shouldn't be doing. That jumps us to 41.20.52, which is a new section. The issue we have here, and again, this is another clarification that we have. The language that kind of jumped out as an issue is where it says, and I'll read the entirety of it just for the record, and I'll point out what I'm talking about. The BWC shall be used to record all consent searches, vehicle, residential, and structural. The deputy shall capture the full consent process on BWC as read by the deputy and authorized, denied by the informed individual. Is the intent here that, as we know that most of these consent searches, you're actually not gonna pull out your consent form and read it. It's organic, you're having the discussion based on the scenarios. Is that what we're talking about, or are we talking about you actually have to pull it out and read it every
As
time?
opposed to pulling out and reading it, hey, how you doing, I'm Sheriff Chitwood, we have reason to believe that whatever is in your car, would you be willing to give me consent? And you have the ability to tell me no.
Yep.
And you're free, whatever you decide, and that's all I want.
So it could be organic, it doesn't have to be read off of people.
Just as long as we hit, and it should come from the training division, as long as you hit those key points so that it doesn't get suppressed in court,
Mhm.
that, I don't need a written form here, here it is right here, you can see, it. There was no, because I don't know how many times you lose a suppression case because there were 10 cops around when you asked for, here you see it, you hear it, and it covers the points, it was voluntary,
Mhm.
no coercion whatsoever, and we told them, what the scope of the search was.
Okay. Good. Okay. The next is 41.20.53. And we have multiple sections in here. The simple thing, and we'll end up talking about this as I move forward down to 41.20.59, is actually it's been struck in this section. And as I'll kind of go through, you know, it would be our intent to actually put .59 back in there for this would, the reference we want to keep in. So it's really just a housekeeping issue. And we'll kind of, I'll get down to .59. That's witness recordings and property crimes. And so we'll kind of get to, that's actually one of the issues we were talking about earlier.
What were you saying about the prisoner detainees? You know, did you say something?
We can jump down to it now if we're obviously looking at it.
Whatever, I don't want to.
No, it's fine. So 41.20.59, which is the next page, 8.13. So essentially, this provision right here, goes through and discusses a distinction between different crimes as well as the consent. I think that this actually is a good example of an exemption that I think is necessary to provide one of those catch-alls that in a situation where you don't actually have to, you know, activate your camera. And I think that it would be, you know, something that we could you know, leave in.
Okay.
And obviously, again, our proposal would be to keep it in, therefore referencing back to actually keep it in that .52, which is voluntary consent to search.
Say it again? You want to do, what do you want to do with 5.2 and?
5.2 would just be a reference to 5.9, and again, we're proposing to keep 5.9 in. So we can jump down to point,
Back up to 57.
well, we're going to 55. I just want to, again, make a note that the school resource deputy, again, we don't have objection. I think it's good to carve out those different portions of it, so no objection at .55. Okay, .56, suspect interviews. There's a portion that was added where it says, shall not stop and start the recording during the course of interview. We have some language, and again, to kind of go over, you know, the difference between intentional as well as some other issues that we'll kind of talk about further down. So the way that we have it actually drafted up is shall not intentionally stop and start the recording during the course of the interview except as provided in the section. Again, to make the distinction between intentional as it relates to the discipline is just up to dismissal, or not is up to 5 days. So I think it's important to keep that distinction in there.
I guess my question back to you is, if you put them in the box, and you're interviewing the suspect, you're not going to step out of the box and turn on the camera and go back into the box, because you'll never get that past the state attorney to get approved. So if you're interrogating or interviewing a suspect, what would you stop the camera for and then turn the camera back on? You just blew your confession.
Well, and I think that's the point. So that's why we put intentionally in there, because what we're talking about is accidental. Talking about you're doing it, something happens, you hit something, you're doing something, it gets turned off. I think the distinction is really important to.
Yeah, but I think that goes back to when the supervisor says, hey, he banged into something that went off, or the wire got yanked out, or whatever, that would go back to the sergeant saying, oh, hey, there's no violation here, you know, under that catch-all phrase.
Well, you know, part of this is, you know, we're hoping that you know, what we originally proposed as it relates to all these things get incorporated, but, you know, some of these kind of have to be self-contained. So for example, if you say you don't agree with certain portions of what we've already proposed, you know, this would be a self-contained provision to address that. Because again, intentional was something we talked about at the beginning. If you guys don't want to make changes to that, then, you know, we would need the protection in this particular article.
This isn't referring to somebody in the box, because we don't typically use BWCs to record those interviews, because they're already recorded. I think this is more geared towards, on the side of the road, you go start talking to a guy, all right, let me get back here in a couple minutes, you go start talking to somebody else, and maybe it's the victim who doesn't want to be recorded, so now you've stopped it.
Yeah, but then if you, that clarifies that, you just say, the victim says, I don't wanna talk, that's fine, you're good.
Well, you were talking.
The example I was using was in the box was, for admissibility purposes, you wouldn't turn off the camera when somebody's in the interview room, when you're taking a statement from them.
Well, I
So I'm
agree.
saying on the side of the road.
Yeah, no, that's-
I'm talking about if you're talking,
Yeah.
and you're talking to the bad guy, and he's giving you info, for us to turn it off, to do whatever, and then go back until you're done talking to the bad guy, would taint what we're trying to, the whole purpose of the investigation.
I think what we're trying to get to is, on the road, the guys are they're going, well, what if something happens to my camera while I'm talking and it stops? I'm gonna get fired, or I'm gonna get this, or I'm gonna get, that's the mentality that's prevailing on the road. And so by adding the word intentionally, then that means that they had the deliberate act, and yes, maybe there should be some discipline there for that. But for the accidental, these guys are still kind of like, man, if my camera malfunctions and I don't put it in the call history, write it in my report, call the supervisor, and, ring up whoever else I have to ring up, I'm gonna be standing tall before the man and getting in trouble. And I think that's what we're trying to clear up in there, is kind of put these guys at ease, that we understand these are instruments, there's gonna be some malfunctions. We're not looking to take you out because you didn't do it on purpose. And I think you've addressed that in the extent that it can be the supervisor's job to document that and forward that, but a little added comfort level probably, if nothing else, would be to have it in a policy.
One of the examples we talked about as well is, a lot of times, when you show up at a scene, the person who you think is the witness ends up being the suspect. The person you think is the suspect ends up being the witness. And
That
so.
happens in Deltona, by the way.
And so, I think the idea here with that as well is, well, what happens if I walk up and, I end up talking to somebody and all of a sudden it's, this is something I should be recording, I didn't do it. Are we talking about intentional or mistake? So again, the language here is to
Well, but
encompass
but
those.
this is starting and stopping.
Sure.
I mean, this issue is,
Well, sometimes you-
it's already going and you stop it, as opposed to the situation where you walk
Sure,
up
well-
and say, should I be,
Well, what happens if you go up, you start talking to the person you think is the suspect? You turn it on.
Right.
You start talking to him, you realize that maybe he's not the suspect. Maybe there's something that I need to turn this off because maybe there's some personal information. Oh, wait, maybe they're not. Maybe they're a witness or a victim. You turn it off, and then you realize later on, oh, maybe they are. You gotta turn it back. I mean, there's
Yeah,
a
but that's
million.
why if you keep it running when you come out, because you're investigating a crime, I'm assuming you were dispatched there to keep it running, all that stuff can be cleared up and explained.
Again,
Because if you start giving people the ability to turn it on and off, the things is gonna go wild on us.
but the policy does say that for victims, you have to tell them.
Well, that's gonna change.
Okay, well, so again, I mean, there's all these different scenarios where
Yeah.
you get there, you think he's a suspect, oh, wait, now I think he's a victim, I tell him I'm filming him, I don't want to be recorded, you turn it off. Oh crap, now I realize he is a suspect, I gotta turn it back on. So, again, there's a million different ways that we can address it, so.
But we're gonna talk, these things you're giving us because we're gonna talk about.
right, absolutely. But from what I understand, the concern is that you start that conversation, you start that interview, you turn it off for whatever reason, and let's just, totally valid reason to turn it off. Turn it off, and then you realize, you really need to talk to that guy, you go back, you turn it back on, then you open up yourself to, a good defense attorney's gonna turn around and say, oh, well, wait a second here,
So let
the
me-
information isn't being recorded here.
Let me
during
just
that
put
interim."
this out there, and that is, I don't think that we from the deputy side of things, have any issue with where you're trying to go with, turn the camera on when you get there and turn it off when you leave. The only time that we feel that we should turn a camera off is, hey, we called the legal advisor, I went and talked to my sergeant and said, hey, I got some issues here, can you help me kind of work through these? Or, a deputy that came on scene, and you guys both walk away from it and say, hey, look, I go in this direction, maybe look at this. That's the only recognizable reason. Short of that, leave the damn thing running.
Here's my thing is, you get dispatched, you turn it on, you get out of the car, you make an arrest, he's cuffed and stuff, the camera goes off. Hey, Sarge, this is what do I got, how do I write the report? Hey, Brody, you did this before, how do I do this? That's all stuff shouldn't be anywhere on the camera, nobody should see how we do that.
But the policy doesn't allow that until the guy's brought to the branch jail.
Now, we're gonna talk about that.
Okay.
Because I don't, this is just me talking from the experience of
Sure.
Daytona. Once he's cuffed and stuffed and in that car, we're done. Your job is done. Now, you wanna write the report? You need to call and ask for help?
So you understand, the previous administration wanted us to capture from the time that we put them in the car, they want everything in the car so that we captured the entire ride to the jail, so there were no allegations against the
Yeah, I'm not-
deputy.
I'm- yeah, I'm not.
Unless he's in the middle of confessing, or he turned into a Bay Craig, pounds held
Sure.
one of those.
Then you would, then it's something
Absolutely.
reactivated, that's not taking the winds out of the car.
we
and
support
whatever.
that. We think that there's some room here to fix this so that it works well and.
Like I said, that's the goal, turn it on, when the job's over, turn it off, then when you wanna do all your talking and phone calls, you're done, whatever you did, and when you write the report, you're good to go.
So what happens though in that case where, say it's a DV case, and you get there and you've just got these two different stories, and the guy says, hey man, that deputy's gonna stay in the house and hang out with them, I'm gonna go outside and talk to the sergeant. That's what we're looking for here, is the opportunity for him to go off the camera, go out and talk to his sergeant and say, Sarge, I need some advice here. I'm new, I've been on the road for 6 weeks. How do we get to that point where the guy can say, hey, I'm going off camera to talk with my supervisor? And I think I think when we switch over to the newer cameras, there's an even better alternative, because it's my understanding that the new camera system has the function where you can mute it and leave the video running. And we would not have an issue with that if we said, hey, look, I'm going outside, I'm gonna go talk to my supervisor, I'm muting my thing while I talk to him, you're still capturing video to see what we're doing, nobody can come back and say, hey, no, you were threatening me over here. I think there's an opportunity there that we would be open to, but in the interim, can we get to the point where these guys can go out and talk to their supervisor and not have that conversation become part of the defense's cross-examination?
Well, it's one of those things where people aren't going to ask for questions and help if they know they have to be infallible on the first try, because it's all gonna be recorded.
See, and I understand there are two different issues here. There's obviously the criminal aspect of it. You know, there's the part that I deal with it, which tends to be the disciplinary action. When there's a potential for disciplinary action there because an officer didn't do what they were supposed to do, and their position was, hey, I called my supervisor, ran it by, I did what I was supposed to do, sergeant told me to go do this, and I did that. And, I like having that recording from the standpoint is, this way, I know exactly who's telling the truth. I don't have to rely upon the sergeant saying, absolutely not, I never in a million years, and the officer saying, wait a second here, I'm getting set up because I did the right thing and I was told, I did exactly what I was told. I don't have to sit there from when I'm evaluating a case trying to figure out who's telling the truth and who's not, so.
You made the point of, the savvy defense attorney. The savvy defense attorney's gonna say, man, this guy, he doesn't know.
He
what
couldn't figure it out.
He couldn't figure it out. Why should I?
No, I know,
figure
there
it
are
out?
different, depending upon what the use is, there are different,
But I don't think body cameras were put out there in the intent of trying to capture
Yeah.
the deputy and the supervisor going back and forth. It was intended to bring trust with the public, not to use it to screw
Well,
the
bouncing
deputy or-
ideas off your fellow
I would
deputy.
hope that none of my sergeants would ever do that.
Yeah.
And we just had one that came in and said, hey, you're disciplining the guy, but he did exactly what I told him.
yeah.
But again, it could be bouncing ideas off of not just a sergeant, but a more senior deputy. A guy's here for a
That's what
year.
I'm
or
saying.
2
I
years.
understand where you're going with that, I hear you completely, and I'm gonna check into the mute button thing.
Okay.
Again, like I said, when you're cuffed and stuff, and which happens most of the time, then do what you need to do.
Yeah.
I think Brody's point, you're trying to figure something out. As long as there's another camera running, what's going on inside, so nobody can come back in, like you said, and said, he did whatever.
And what we're talking about, just for your record, Sheriff, is .74, which I reference here in my number 14, but just to kind of give you an idea for your notes. That's where, the portions have been deleted as it relates to facilitating intelligence gathering, I think is kind of what we're talking about as well. So, and I think that's the intent that we anticipated it being. So just for your own purpose as you're having your discussions. That jumps us to 41.20.57 and 5.8. this is again what we were talking about as far as the obtaining consent for crime victims. And again, you know, part of that also, as we discussed before, you know, the kind of organic nature of some of those discussions as well. And I can kind of, I'll read the inserted section. So for 5.7, it says, this is a brand new section, when the deputy identifies a person as a victim of a crime through on-scene investigation, that deputy with the BWC still activated must on video notify the victim that he or she is equipped with the BWC and that is being recorded. The deputy shall then request consent to continue recording the victim. The victim requests may not be recorded. The deputy shall, while still on video, state the date and time out loud and indicate the BWC shall be deactivated for such purpose. The entire procedure shall be recorded on video and notified in the deputy's report or CAD if no report is completed. The same thing goes for a juvenile. The juvenile is a kind of separate issue we'll talk about. But you know, as we understand here, you know, we want the cameras to be running all the time. And you know, I believe that earlier in this policy as well, it says that you don't have to turn the camera off if you don't want. So what we're trying to figure out here is what is the situation, and we can get some clarity from you. What's the situation, and really what's the intent and purpose behind this?
Let me check with the legality of what we gotta do about you turn on.
Yeah, 'cause I thought that was-
I don't know if that's something that came up.
That's what I wrote down, is I think there was case law.
We'll-
Yeah, that
I
was-
thought there was case law that says as long as we were in a place that we had a legal right to be, that there was no
Expectation of
expectation of privacy.
I think the only time you get the notice was when you were inside the residence.
Okay.
We'll double check
Right,
that.
there is an issue inside the
Yeah,
residence.
we'll take a look at that and we'll figure out a way.
Clarify as well.
Yeah.
And so the second goes for the juvenile, and I understand what we're saying for a juvenile, the way this is written, and I'll just, again, read it for the record. If the victim is a juvenile, the same procedure shall be followed. However, consent should be obtained by a parent or legal guardian. The issue obviously pops up to us is, well, what happens if the legal guardian isn't there, and he says, I want to be recorded, does that mean you can't question him?
Yeah, you gotta, we're gonna.
So I'm just curious, have these issues, because this policy's been in place since.
These are
March.
new, these are brand new additions.
It can't be brand new.
This has been in place since March.
This has been in place since
Okay,
March.
okay.
So I'm just curious as to,
I mean,
has anybody encountered that? I'm just kind of curious as to how we've handled it as a
From
practical
from a
matter.
legal point of view, if there isn't a parent or guardian around, and based on the deputy's experience and how old this kid is and what he's been through in life, you can question him without a parent, you can document. I couldn't get hold of a parent or guardian, he's been locked up 6 times, he's 17 years old, he understands the system. If that's all we put, that could be an admissible statement if you get that.
But with this, we'd have to add one more level to that, which is that not only could not get a hold of them for their consent, but their consent to video it.
What does our what's the policy on juvenile say?
I have to go back.
We'll take a look, yeah, we'll take a look.
And just to throw some other, as I sit here and think about this, as it relates to that victim saying, I don't want you to record me. So you're at a DV call where the victim's in one room, the suspect's in another, and now all of a sudden it goes to hell in a handbag, and nothing's gonna be on video. And that's why I think we'd be better off just let the damn thing run. And, you know, don't give them the opportunity to say, I don't want to be recorded. If they want to exercise that right as we walk through the door because they see the camera on our shoulder, then we'll deal with that. And we probably need to look at what the law says.
We'll take a look at the law says, that definitely, that way we're on par with the law.
Okay. The 41.20.59, we talked about it a little bit earlier, but I'll kind of circle back to it. The big thing here is it made a distinction between property crimes and crimes against persons. Is, again, the intent here that there should be no discretion as it relates to victim witness interviews as it relates to property crime investigations.
I'm a little lost here. Which, were you still on
41.20.57.
57.
59.
5.9, okay. That's that one that was struck.
It was struck, and that's correct.
Struck. Okay, you were asking, is the intent,
So, I mean, we understood that, you know, essentially it allowed some discretion with the deputy as it relates to victim witness interviews as it relates to property crimes. I think that, you know, our position is that discretion, I think, is
The
necessary.
history behind that is under the previous administration, we were forbidden to record people in those cases. And we raised a concern with that because there are times when somebody reports a crime when they're actually the suspect. They're trying to report their car stolen, and we go make a case against them, well, we want to have that on video. So they allowed us, that was their change to allow us to do
We'll
that.
take a look at that, because CID, you get called to the house for a DV, and then 2 weeks later, reporting our 55-inch television was stolen off
Right.
their living room wall, and you go back and pull the DV, there was no 55-inch television on the wall.
Right.
So we'll take a look at that.
Because the thing is that, and I guess kind of looking through this, is that covered by 41.20? I guess it's 7.0 in the current policy, but 7.4 in the marked up version?
Mr. Mandel, I think that seems to be a lot of the problem these deputies have with this policy is that it's 13 pages long, and you read over here, now there's maybe something over here, and, you know, I think, you know, that's been the problem since this thing first came out, was there's so much there to try and keep track of and follow that you don't know which day of the week you're gonna be, you know, sideways with this thing. And so what you're experiencing here, where it's in one spot, and maybe, isn't there something over here though that gives me this exemption? It becomes a little troubling from a practicality standpoint.
Well, I think part of the problem is that looking at two different documents. Because the strike-through, there's a difference in numbering between the strike-through and the final, because the strike-through took out certain sections. Because it seems to me, and look, I could be totally wrong, but it seems to me that there was an intent here to put all of the failure to record, the reasons for not recording, the acceptable reasons for not recording in one place.
Well, I mean, there's only 2 sections that were added in that failure to record.
Right, but the thing is that what we're talking about in the current 41-2070B, where it says deputy exercise discretion during citizen contacts or enforcement actions. Does that cover what you're trying to put back in? Or is that, or do you view that, what you're trying to put in, as something different than what's covered in that section? Because to Brody's point, everything we put back in and everything we add makes it even longer.
Yeah, and it was 11 pages in 2016 when you guys negotiated this for the first place.
Yeah, hey, look, here's, reasonable minds can differ,
Yeah.
but my position is always, when you have exemptions to a policy, you put them in all one place called exemptions, so this way, if somebody's looking for the exemptions, they go to one place without having to read 13 pages to figure out what the exemptions are. I mean, that's my preference.
Yeah, no, and I think,
Mine is duplicative, have them there and an exemption section.
Okay, you know, and like I say, reasonable minds,
pages, Tom.
reasonable minds can differ on this stuff.
That way they can't say they missed it.
yeah. I'm always gonna put on the side of more exemptions.
But then Brody's gonna get mad at you because it's too long.
I don't think he will.
I like exemptions.
That's right, exemptions are good. You know, and again, I think that, you know, a couple of these, you know, maybe can be addressed in the beginning of the policy, and I think there's obviously some things that need to kind of be ironed out. That's why we're here. So, you know, we can kind of continue going through.
Yeah, let's go through it.
But I think that's, I think we are on the same page, which honestly is, you know, makes me happy. So, they don't always go that way. I think we were at 41.20.60.
Yep.
I mean, this is just a should to shall. My alternative language here was to, again, put back in that shall as soon as safely possible activate. So again, I think we are kind of going back to the same idea, but you know, if we can agree on that and put it somewhere that's noticeable and that affects the entirety of it, I think that would eliminate a lot of this.
Understand.
41.20.61. I'll read it. Again, for the record, it was stricken. Regardless of the events requiring activation as defined herein, Above mentioned definitions of required use, any encounter with the public that becomes adversarial or confrontational shall be recorded as soon as safely possible and shall continue until the contact is concluded. And there's a note that was not stricken, which is, note, all citizen contact shall be recorded activation prior to exiting the patrol car. And again,
Yeah, that goes back to the question that we were talking about before that we're gonna look at with respect to
Correct.
the citizen counters.
correct. Okay, jump down to .64, which is details and overtime. The issue we have is, obviously, you know, the entire .64 was deleted. I think that there were some important exemptions here as it relates to working details and overtime. You know, the first was that, as it relates to, the location of the dock and the detail in the deputy's home. And then the second one is, as it relates to whether or not that deputy had been trained on it or not. I think both of those are important, and, you know, obviously we'd be requesting to go back in. I think it also creates an issue, as it relates to the dock, with compensability for travel time. And I don't know if that's something you guys looked into. You know, obviously donning and doffing is a big issue with law enforcement, always is. But if we are, you know, if you guys are requiring that they have to go to their home location to pick up their dock before they go to a detail that may be located on another side of the county, you know, where's compensation coming from there? I think that's an issue.
What did we do with the docking?
Well, that's why we put the spirit of EWCs out, so if they're working in detail, they can go pick one up at a district.
Okay. And then donning and doffing was on you, we talked about that. Go ahead. I thought we talked about that.
A little bit. You know, once we require them, then we're gonna pay them.
So here comes the question now, though, from an administrative standpoint. You've got a deputy who is working an outside detail. The person that's hiring them wants them there at 3 o'clock. They now need to drive to, say, Deltona to get their camera, or grab a spare at a local district, and they're gonna have to be there earlier than that, but they're not being compensated by that entity to go get their camera.
That's what we're talking
So-
about. Because,
So we put in time for it as,
yeah, we'll work on that. Because I will tell you, you're not gonna like what I'm gonna tell you, but I read a recent court ruling when it came to mandatory equipment where donning and doffing did not apply. So,
well, it's a very controversial issue for law enforcement. It's a very interesting as it relates to body cameras. I don't know if it's been particularly addressed in this form. But I know as it relates to, you know, private sector, where we're talking about mandatory, like, safety equipment, you know, sometimes it does. I don't know if it's been addressed, which obviously creates an issue that I don't think.
I would personally charge the guy. Charge the
The entity.
because, hey, this is gonna protect you as well. And you're just
I mean,
gonna pay
obviously,
extra hour.
the safest bet for the sheriff's office to avoid any sort of, you know, FLSA issues is compensation, and I think that's the right way to go. And I think-
Historically, didn't they try to provide the deputies with a docking station at home and it was balked at?
Yes. We had several defense attorneys that said the minute you put that in your home and start docking and uploading data through your home, then that's gonna expose your home system to subpoena, and other issues. Home computers. There was a case somewhere where, and I don't know what the resolution to that case was, where they subpoenaed the officer's computer, and they were fighting whether or not he had to give it up. You know, so that's why we said, we don't want those things in our homes. You know, I think that the concern here being is that we're such a large county. A guy that lives on the east side, works in Deltona, he now has to drive to Deltona before a detail and then drive back to a detail, say, in Ormond Beach.
No, they can go pick up.
Go pick up
the
the camera.
Okay, so he goes and picks up a spare camera, but even still, he's gonna have to go early so that he can still make it to the detail location. Who pays for him? The way we see it is he goes on the clock when he gets to the district to pick up his camera. We're gonna pay him the drive time to the district, but when he gets to the district, that's where his shift starts. Because he's now gotta show up and get equipment to go work the detail. And then the other question that comes up, Chief, is how are we gonna address this at the Speedway when you have 100 deputies that we don't have 100 spare cameras on the
Well,
east side.
Good luck getting 100 deputies working at Speedway.
Well, I agree with you.
Number two, the rule still applies, they need a camera on if you're gonna be at the Speedway, it's still an outside detail.
Well, is it an outside detail?
I was having a big discussion about that last week.
I would say it is,
Okay.
and the fact that's the direction I gave Chief Morgan, it's still an outside detail.
But still, so what you're working on is some form to document the time before the detail, if you're not charging them.
So now how are we gonna deal with this? Because is the Speedway gonna pay these deputies to drive Deltona?
That's a whole separate conversation we can have later, and I
Okay.
think we're all like-minded when it comes to that
I
particular issue.
agree, but my concern is that these are things that we've gotta work out because, I mean, the races are coming up here in 2 weeks.
So are you guys gonna be issuing directive in order for them to at least put time in, and then you guys can figure out?
We're not gonna order anything yet, we're gonna take a look, 'cause
That's
we're gonna take a
outside
look at
detail,
it.
it's not
I guess
mandatory.
so I understand the issue, I'm a little confused here. Because I guess you're saying, they know they gotta work at the Speedway, but their cameras are somewhere else?
Correct.
Yeah, so
But they're not taking them home and docking them?
No.
They don't.
they get
can't
docked
take
in
them
wherever
back.
their home district is. So if a kid,
Okay.
he may live in Port Orange or Daytona, he works in Deltona. His camera is docked in a
Okay.
docking station in
I
Deltona.
know what you're saying now, earlier I was
Yeah,
confused
no,
what
that's
you
fine.
were saying. Okay.
But I think the Speedway creates the other elephant in the room with regard to
Spares.
we're being paid directly by the Speedway outside of the sheriff's office normal means of an outside detail. So who's going to compensate the deputy to go get that camera and now travel over to the Speedway?
I would ask to look at recent court cases and see if we have to do,
Well,
if
there's a
the
little
county
difference. I
has to
thought
do
earlier
that.
you were talking about they were off duty, you called them up and said, come here.
No.
Yeah, that's what I thought
If
you
you
were
live in
talking about.
Daytona,
Now I understand
you
what
could
you're
go to Ormond
saying.
Beach and pick up the
I
camera.
was thinking, well, we called you, put you on the radio and go get your camera, we would owe you because you're under our control, but this is a whole different
Right, this
situation.
is an outside choice. that-
These are usually scheduled days.
Okay, I understand now. I didn't know that. I
Yeah.
thought earlier, you called up, you got on the radio, you said you're on duty, go report here and go there, you're under our control.
Which,
But that's
That
not the
occurs.
case.
I mean,
in my opinion, the entity that's hiring the detail should pay
Right.
the dime,
I
should pay
understand.
whatever.
Well,
it
there's
is.
a different, there are two different
Yeah, let's talk
situations.
about
Now
it.
that I know that, we'll look into it, but I understand now what you're saying, so we'll, I like the sheriff, we gotta
I'm
look
saying
into
we,
it.
the county, should not have to
And-
pay that, it should be.
and-
the
and
outside
I
entity.
understand what you're saying.
to throw one other level in there is, there's a multitude of deputies who aren't assigned cameras or they may work in the courts that are out there. Are you expecting that they're eventually gonna have to start coming up with a camera to go work at the Speedway?
We'll talk about that, but
Okay.
right now, the policy as it is stands, if they're not issued a VWC,
Okay.
we're not requiring them to
Okay.
do that. So we're not trying to put a burden on them, but if they already carry one,
I'm more focused on the spares. Under the policy, if they're not issued one, that they have, and they're going to work a detail that requires them to wear a VWC, they would have to go recover a spare. But there's obviously not enough spares out there to accommodate that.
right.
Or if they haven't been trained on it.
Right.
That's the
Well,
other
we've
issue.
already dealt with that. To your point, when we run out of spares, we run out of spares. It needs to be documented for the CAD, when we log it on.
Yeah.
I'll let you know of what we're probably gonna encounter in that situation is all the spares that have been down in the district, absent the camera and the battery pack, have probably been pilfered. Because when a wire goes bad, we pull the one out of the spare, we give it to the deputy, put him back in service, and then we start the fight with IT to try and find it, or to get the replacements. So I can tell you, in the district, I work in District 6, I think we have one cord and we have 4 spare cameras. So, every time a cord goes down, and it's more frequent than not. So I guess what I'm saying is when we're doing these new cameras and stuff like that, that's something that we probably need to make sure. I mean, I understand they have some, but just like my name tag, if you ever try to get the little backs to hold it on, like you have to get a 3-page memo from somebody to get a couple of things here and there. So that's an issue that's gonna come up with trying to issue these guys spare camera. I can give them all the cameras and batteries you want, but it's not gonna work because we don't have any cords and head mounts and things like that.
What's, if you don't mind, while we're waiting down this path, what's Lieutenant Captain say in the district?
I think we work it out kind of amongst ourselves at the sergeant level, calling up to IT and saying, hey, can we get a spare? To be perfectly honest with you, I haven't brought it to a captain or lieutenant, so I don't know that it's an overwhelming issue, but in the sense that the captains and lieutenants are on that, because the guys that are in the district have their own equipment. It's when somebody comes in to use a spare or a camera goes down, we're starting to part stuff out to make a robot, so to speak, to get them back in service.
If we went to that single unit, we wouldn't have that problem.
Well, if we went to the single unit and there were huge problems there, we wouldn't be at the table.
Touche, right? Okay, what's the next one?
6.5. Again, still pulling page 8 right there at the bottom. We have a deletion there with other agency personnel that involve case strategy, which is again, we were talking about earlier, or conducting while not in contact with members of the public. As far as an exemption, when shall not be used to deliberately record. The addition, I think, is good, which is conversations of fellow employees, without their knowledge during routine non-enforcement related activities. But I think the deletion, if we're deleting it here, we're deleting it in the other spot, I think it creates an issue, because there is no redundancy here.
We'll look at that.
That fellow employees stuff kind of dovetails into what we talked about earlier with the buffering mode now, where it's capturing all that, so.
The audio, especially.
Yeah, but you've convinced us with your examples that we have to have that minute and a half.
Video.
Video, I don't have an issue with video, it's the audio that we seem to.
41.20.67. This section was deleted as well. This relates to being on a perimeter. And again, I don't see, or a static post. I don't see the reason for the deletion. And maybe you can kind of explain, what the intent is or what we're intending to capture here.
Take a look at it.
Okay. 41.20.68. I think this is the one we kept referring to as far as being changed, related to getting people's permissions. And so I'll kind of read it and we kind of, work through it together. So it reads now, deputy shall not record members of the public when that individual states he or she feels inhibited sharing information while being recorded. The deputy shall record the request on the video prior to the deactivation. The way I understood it before is that it gave some discretion before. And now the person actually has to say they feel inhibited. Which again, I don't know what the intent there is. It's eliminating some discretion. I don't know what we're trying to capture there.
We'll take a look at it.
Okay. Point 7.4 would be the next one. We've already discussed that one. Again, that relates to facilitating intelligence gathering and eliminating some of the failure to record. I don't think we need to go over that again. The last one would be point 7.7. This is a new section. I'll read it for the record. In any circumstance required VWC recording of a consent to search vehicle, resident, or structure for which the VWC is not utilized by the deputy to capture the full voluntary consent, the respective deputy supervisor shall investigate the circumstance and complete a memorandum to the sheriff detailing the action. I think that, the issue here is not in and of itself, but more of the lack of discretion with the supervisor. If the supervisor is there, discusses with the deputy, and it's not a big deal. The way we read this is that actually, essentially, you're starting up an IA on almost any of these situations. And what we would like to see here is a little bit more discretion within the supervisor to determine if it's inadvertent, it was a mistake, something happened, malfunction, and not have to actually go through the entire process of investigating the circumstances and completing a full-on memorandum. So, that's the intent there. Like I said, I think we understand what you're trying to do as far as making sure that it's all within that purview of the supervisor, and we kind of talked about that before. I think we agree with that. It's just, it's a little, language is a little harsh.
So is is the objection to this, the concerns, doing the memorandum, or is it the investigation side of it?
I think it's the formality of it. I think that what we're pointing out is that I don't think it necessarily has to be a formal inquiry every time. And I don't know if we're falling at that point, are these gonna be falling in the IA file? I mean, where are they gonna be documented? You know, how are they gonna be recorded? I think these are all issues. I think it's a little bit ambiguity here, so we'd kinda like to see some, you know, discussion on it. But,
What have we been doing, or have we had any? We haven't had any.
it kind of goes back to, you know, the same thing that we talked about over and over again, is that, you know, our intent from our side, and I think you understand and recognize it, is we want to make sure the guys feel comfortable continuing to do their job with the body worn cameras. I think they can be helpful in a lot of situations. What we don't want is for guys to be so scared that they can't, you know, have a mistake or mess up or have something not function, or they forget to do something, or they don't follow the entire policy because, you know, it was confusing to them, and then now they're suspended or, God forbid, terminated for something that was inadvertent and not intentional.
Because I'm assuming that you want to have if there's a situation where you need to have consent to search and it's not captured on the video or only part of it, you want to have some documentation.
Correct.
So
When
that
it goes to
later
court,
on,
it's gonna
you
be
can go
what was
back
done.
and say,
Hey,
this is
what was
why.
done and this is what happened.
As opposed
And
to.
I know you keep hammering home the fact that, you know, an inadvertent mistake and somebody's gonna get fired. I don't see that. I've been a police chief and a sheriff for a long time. I've never fired anybody for an inadvertent mistake, or somebody didn't understand the policy. Because by the time it gets to me, it's going through other levels. So you would say that the sergeant's out to get him, the lieutenant's out to get him, the captain's out to get him, the chiefs are out to get him, and now the sheriff's out to get him. So the inadvertent mistake, they flush it out. These guys do a great job of letting me know, hey, this is what happened now. They may disagree, they got a written reprimand for it, but nobody's gotten fired for it.
Well, the way we're here, you know, we're not here, we're talking about a policy and the way the policy's written. We're not here talking about, you know, supervisors and, you know, relationships between people. We're talking about a policy. And I also understand that law enforcement officers, when they read a policy, especially an investigator, if it says X, Y, Z and you messed up and you did it, you gotta get punished for it. And so what we're here to do is we're here to make sure that this policy is written so that not only our guys understand it, but the investigators understand it, the supervisors understand it, and everybody from top to bottom has the same understanding of how it works. So, you know, I appreciate, you know, the statement, and, you know, that's obviously something the guys wanna hear. But, you know, what we're here to do is to make sure that it's documented properly. So, and again, I think we're all on the same page,
Sure.
really.
And what I'm just trying to figure out here is that whether you all are adverse to having, memorializing in some fashion the reasons why the consent is not captured on the
We don't
body worn
have,
camera.
and Sean can probably correct me if I'm wrong, but I don't know of anywhere else in the policy manual that mandates that a sergeant's going to do a memorandum for an issue that might arise. It usually, we have processes in place that, hey, if we've got a guy who we think, in this case, is routinely not doing something, we do what's called a supervisor's inquiry, and it starts the process and it moves its way up the chain. But to say that, you know, every case is gonna, that this guy makes a mistake or whatever, now you have to do a memorandum to go, it seems like it's guaranteeing the process is gonna get started. And that's what the deputies are worried about.
Not doing consent to search is a big mistake.
That is a big
That's not-
mistake.
I don't
That's a huge
say that's a
mistake.
little mistake, that's the kind of things you get sued for.
I mean, you know, and so the sergeant, if he can justify it, is justifying it even when it goes to the court, when it goes to court. Well, what happened? Well, this is what happened.
Well, I guess where I'm going with it is that if the sergeant catches wind of it and the deputy says, hey, Sergeant, just forgot to hit the button or whatever, or and he documents it in the report, and the sergeant says, hey, don't let it happen again. He never has another problem with it. Why do we need to create a memorandum to chase this thing all over?
Because when we get sued and when we go to court, the sergeant's, don't worry about it, I'll take care of it. That's what's gonna get us in the sling. Where at least if he does, the sergeant, I can say comfortably to everybody, the sergeant did his job. He went out, talked to the deputy. I'm quite happy with his inquiry that it was a mistake. I can live with that. He documented and memorialized it, and we're good to go.
Okay, I guess
We agree to disagree.
Hey, we've only heard that once so far, so that's pretty good, right?
Yeah, we're ahead of the game.
So that's all the issues that we have for body worn cameras.
Okay.
you know, we obviously have a secondary issue or second issue that we're talking about. I don't know if you want to address that now, or if this is enough to digest for today and you guys want to go back and.
Actually, it seems to me to be more efficient for you to tell us the concerns you have with that as well, so this way we can go back and look at everything. Sure.
You have a clean copy?
Which one?
Yeah.
Here you go. No, here.
Can I keep that?
Yeah. Yeah, I left the extra clean copies here as well.
Oh, yeah, I gave it to you.
Yeah.
Here you go. You guys want to take a break or a coffee before we start on the next one, or are you guys okay? We can kind of run through it. Yeah. It's fine. There's way more copies than we need. This one I'll say, I'll preface it with a couple of things. So the first is that the first two items, obviously, you see are kind of referenced in generalities. And we can talk about them in generalities and what the issues are. The reason why we weren't able to be as in-depth with this one as before is because this policy change actually was not in legislative format. So it's extremely difficult for us to actually go through and see exactly what was changed, when, where, and how. So, again, with that being said, it's definitely not as in-depth or specific. So we can kind of talk about those.
It's actually, as far as I knew, it's 1.1.30 and 1.1.31
Copy that. The rest of
are the new ones.
I don't know if I have extra copies of this.
Here, you can share with me.
Yeah.
Here, this is it right now.
Yeah, so you're right, it is 1.30 versus 1.31. Again, it's, if you look at at least the copies that we have, they're not in legislative form.
Right, that's correct.
Which again, created an issue.
Yeah.
You know, the issue that we have with the moving vehicle is really kind of, I think it kind of focuses mostly on .31.
That's what I said before.
And specifically, as it relates to deputies being forced to get out of the way of vehicles, it creates some ambiguity here, and I think that, you know, different situations call for, you know, different scenarios. You know, again, we can think of probably a million reasons why, you know, you may have to shoot at a vehicle, and you may not be able to get out of the way, or maybe getting out of the way is not practical. And I think that the changes that we're aware of, and again, I say that we're aware of because I can't tell you exactly what the changes were without it being in legislative form or being able to go through and compare them all. But the changes that we're aware of, I think are eliminating those, the ambiguity or the discretion to be able to do that. And I think that is something that's definitely been a concern of membership as a whole and brought to us.
Just so you know, this policy is a nationwide policy that was pulled from police departments around the United States of America. If you don't stand in front of the car doesn't run you over. As the car is moving to get away from you, you don't reposition yourself and keep firing at the car when it's stuck into a ditch, and you're continually moving and putting yourself and creating that danger. That's what the purpose of this is. Now, we can discuss a million and one what if. If there's a what if in there, then that's what we have the policies and procedures and grievance form to say, hey, and I'm going to tell you, we're not shooting at moving vehicles. This is an industry standard. This is taken from at least a dozen other police departments and more around the country who have the same exact policy.
Talk about some of the
Well,
examples, or-
you bring up about the car in the ditch, and so let's talk about the car in the ditch, because I understand it a little differently than I think maybe you understand it, and one of the concerns that, and what the deputies see out here is, so you've got a person who's carjacked 3 different people now, he's put his car into a ditch, and you believe that he's stopped, and you start advancing on the car, and all of a sudden it lunges to you, and you believe your life's in danger.
I think before we have this conversation, have you seen the Air One video?
I have not seen
I
that.
think you need to look at the Air One video, because the whole incident starts as the car's backing away. I have a deputy chasing the car as the car's backing away, firing into the car. Okay, so the car's retreating, so there is no, well, for deputy's life's not in danger, the car's backing away, and clearly by Air One, you're watching him follow the car and chase the car. Then the car goes into the ditch. Other units are positioned right there, ready to go. The deputy fires, and as the car continues to move away, he continues to reposition himself and continue to fire into the car. That's unacceptable.
Well, and I'm not, obviously, I probably should discuss it, because I'm not aware of the facts of the case. I know we're kind of talking about an ongoing case, which probably we shouldn't do to a particular extent. But, you know, I think that there are, you know, as we pointed out, there are situations where, you know, firing into a vehicle is necessary. You know, if this vehicle is being used as a weapon and has been, is continuing, you know, a deputy has the right to stop a fleeing felon who is armed. And at what point does that vehicle become that weapon? You know,
So your position is, if I have a gun in my car and I'm driving away, the deputy has the ability to open fire on that fleeing vehicle? Was
no,
that-
I don't have any position. I'm talking about a purely
But
hypothetical.
our old policy, and I'd have to go back here and look at it, talks about that to prevent the imminent harm to another person, and it talked about fleeing felons if they pose a threat to somebody else. Well, here's a case where a guy's carjacked 3 people. Should we wait until he carjacks the 4th one and kills him?
He was unarmed.
Well, the vehicle's
He was unarmed, and other units were positioned, waiting for him. If they weren't shooting, he wouldn't get out of, he didn't get out of the ditch anyway. If they weren't shooting, the other units were right there. I think you have to watch the video. The objective is, we're not shooting at cars. We're not doing it. We can go to court, we can fight now, we can sit here and do whatever, we are not shooting at cars. If an area arises where a deputy uses deadly force against the vehicle, and there's a justification for that, then we'll sit down and entertain that. But the policy is a living and breathing document. This is the guide. If the car was mowing down people on the boardwalk, even though the policy says you don't shoot into the car, clearly, the deputy's gonna have to do that, because the car's running down the boardwalk.
Well,
That doesn't mean I have
Might
to
be in
put in the
violation.
policy.
Well, that's my point.
You can violate a policy, but for a good reason. You guys want the policy to cover every what if. It's not how it works. Basically, we're not gonna shoot into cars. You're on the boardwalk, and the car's driving down the boardwalk, and it's mowing people down. You're gonna use deadly force. And nobody's gonna say that you couldn't have used it.
Well, I think, no, you made a good point, and I think that's the point that we're looking for, and I think that, you know, you're right. We're obviously would be looking for some memorialization of that. And I think what I'm hearing is that, you know, you guys aren't willing to memorialize it, but you're at least verbally stating that there are situations that may arise where, one, you're gonna have to violate a policy generally, but two, especially as it relates to this.
Every policy we have, there's always gonna be a what if. You may not be able to use your ASP, you might not be able to use your mace, but you're in a fight for your life, so you pick up a table leg and you crack the guy over the head, and something horrible happens. Well, you're not gonna get disciplined for using the table leg. You were in a fight for your life, and that's what you had to do. You couldn't use your tools.
But Sheriff, it's already written, right? Deputies shall not discharge their firearms at a vehicle unless a person in the vehicle is immediately threatening the deputy or another person with deadly force.
Right.
I mean, so it says it in there. I mean, I understand you're saying, you know, that's how you would apply it, but it actually says it.
Well, again, I don't know what the changes are, but I mean, you look at A, it says a moving vehicle alone shall not presumptively constitute a threat to justify a deputy's use of deadly force. As we're discussing right now.
Right, shall not presumptively constitute it.
Correct.
Right. So there's no presumption that just because the vehicle's moving that it's a deadly object, but obviously, if it's coming straight at you and you can't get it away, then,
There are all scenarios we were talking
well,
about.
first and foremost, I would assume that the first instinct would be trying to get out of the way of a moving
Not
vehicle.
necessarily. There are some people put themselves there so they can use deadly force.
But that's totally separate, because I don't think anybody sitting across the table is gonna say that's a good thing to do.
No.
You know,
I
so,
think that's, you know, to
That's not our
To
assertion.
look at,
Right,
and
I
to look at their
understand.
intention based
Right.
on those actions, I think is
Right.
hard to do as well. You know, why they moved in front of that vehicle is obviously gonna be a question of fact. So, you know, but again, I think that while I think I can read the room in saying that I think we're not gonna agree on this one, I do appreciate the settlement as it relates to
But
the
understand,
policy.
something else that you might not realize, and thank you for pointing this out, is that that what Sheriff is talking about is captured on page 2.
Page 2?
Yeah, at the top. Where it says, due to complexities involved in certain force encounters and the potential for rapidly changing circumstances, Sheriff recognizes unique and unforeseen circumstances rise from the performance of duties.
You're talking about very beginning?
Yeah,
Policy note?
Yeah.
Right, require application of common sense, discernment, and independent judgment. In these circumstances, deviation from established protocol may be required in order to affect the best possible outcome. In that case, it's incumbent upon the deputy to justifiably articulate and document.
Well, again,
reasons.
part of why we're here, and, listen, I appreciate that, but part of why we're here is that, again, deputies read policy changes and they read the policy change. And what we don't want is that people, deputies being afraid to do their jobs based on, and listen, understanding that there are exceptions goes a long way. But I think that needs to be outlined to them.
Yeah, but I think from the sheriff's standpoint is that when it comes to this issue of shooting at vehicles, at moving vehicles, that is the course of last resort. To the extent that you're saying that, yeah, this policy is written such that it's gonna cause some deputies to be afraid to shoot in vehicles, I think that's the intent, is to, to discourage deputies from shooting in vehicles.
I think I would prefer at last resort language.
And I guess the other thing is how do we train our deputies out of this? Putting it out on a piece of paper after a guy's been doing police work and learning things for 20 years doesn't mean all of a sudden that you've trained it out of them. I mean, that's the other side of this. You put out a policy with zero training on it. And that's, I don't think that's fair to the deputies that if you want to take them in a direction that this doesn't occur anymore, just throwing it out on a piece of paper doesn't correct that behavior. So, and now we've got deputies that are in that position that listen, they did their job the way they've done it for 16, 17, 18, 20 years, and now they're feeling the wrath because they found themselves in a position where they thought they were doing the right thing, and they're not. They're transferred to other assignments, and they're struggling.
But, well, let me ask you something, because I'm not familiar with your training. Do you do training specifically geared towards shooting at and moving vehicles?
I don't know if we've done training at a moving vehicle. We've done a lot of training at shooting at a car. We shoot up cars all the time out at our training center.
Because I would assume that shooting at a moving vehicle is the exception to the rule. Like, you could have deputies that could go their entire career without shooting at a moving vehicle. So, believe me, I perfectly understand the issue of muscle memory and, which is something that obviously you want to be trained so that you're not sitting there thinking when it's time to use the deadly force. But I'm just wondering from the standpoint, does shooting at moving vehicles really fall, in that category of things that is so ingrained in every officer that, we're going to have to do something extraordinary to untrain them? And I don't know how you untrain them.
I think it happens probably more times than you think.
Let me refer back to 2016 policy before we got here. It's 1.1.3. It says shooting at or from a moving vehicle is a dangerous and generally ineffective practice and is not authorized unless the use of deadly force is in accordance with this directive. So, I mean, we'd have to go back and talk to the training cadre and see if that.
I can tell you back in 2016, that had that policy and that set of circumstances been in place with the shooting that we're referring to, they would have been 100% justified. That's how we've done business in this agency for years. We've had several shootings.
There's no sheriff in town, Bertie, in all due respect.
Sheriff, and I'm not telling you that you can't change these things. Please don't take that the wrong way. I'm telling you that if we're going to change these things, I think we've got to train it into our deputies and not just throw out a piece of paper and say, hey guys, henceforth and evermore, we're gonna change what you've done for the last 20 years.
To go to Jeff's point, in your training, in my training, we were never taught to shoot at a moving vehicle. Never. Never. As a matter of fact, when you were trained to conduct a pop or car stop, are you trained to get in front of the car and block it with your body when it's moving? Are you trained to reach in? We're trained not to reach in and turn the car, the engine off, right? We're trained that. And when we shoot at cars, it's normally because we made a car stop and the bad guy opens fire on us and we're firing back at him. That's a
Well, no,
completely different animal.
I think what we've trained the guys in the past is that when you feel your life is in danger, it's acceptable for you to fire into that car. Not that, hey, there's other avenues here now that, hey, look, the better practice here is, where can you go? Start training them with that mindset. Maybe it's not so much muscle memory as it's the mindset. The mindset up until you change the policy was, car comes at me and I don't have anywhere to go or whatever, I'm putting rounds into the car and stopping the threat. Maybe it's ineffective, I get that. But I think we've got to change the mindset, and it can't just be through, hey, we put out a policy.
So how would you propose to do that?
Through the annual deputy refresher training, which everybody's going through. Put them into those scenarios and say, hey, okay, here's a car, it's coming at you. Where are you going?
How do you move?
How do you
and
move?
shoot, move and, you know.
The question would
Not
be,
moving and shooting.
why are
I mean,
you,
if
why
you
are
have
you
to,
in front of it, is what my question
Well, I mean,
is.
there's so many
You've
reasons.
never
why
been
you
in front of a
get
car?
I've been in front of it, thank God it didn't come at me, but you shouldn't be putting yourself in front of the car to begin with. And we do it. We all do it. I did it the other night on I-4 when we stopped somebody. You get in front of the car.
Sure.
We do it. But you gotta be thinking, you gotta be thinking when you get up there, you gotta get out of the way.
But I think that's a training issue, that we need
Okay,
to
well,
train
the
that
policy is
out.
still the policy. The policy's out there, start thinking about that.
I think what we've covered a lot, and even in the other policy, is making sure that people understand what your intent is when you say this, and I get it. We're not gonna jump in front of a car and then say he tried to run us over so we can shoot him. I think that's the intent of
It
the
is, that's
policy.
exactly what the intent is.
So, unfortunately, the translation, when somebody gets a piece of paper, is, you better not shoot at a car. There's never, ever, ever in your entire what-if scenarios of a reason where you could shoot into a car, and if you do, the sheriff's gonna break it off on you. That's the word that's
That's the word on the
permeated back
street
through,
right now.
back through
But
the.
where's that permeate from? Because if you read the
Thank you.
policy, it talks about the whole thing. So you read a line, but you don't read what goes with that line.
But I think, Sheriff, that goes back to, here's a policy that comes out. There's nothing in here that highlights to them what's new, what's not new, what have we struck, what have we not. We put this policy out and it said, go figure it out yourself.
Or wouldn't it be better to,
Just like you
when
were at a
in-service
crime,
training
you
comes
show
up,
to the
say,
crime, and you're there to figure out what happened, you weren't there when the crime was committed,
Well, but-
it's a document, and where were the sergeants at when this policy came out? Brody, did you and Sean read this? Did you know that policy note was in there? There's a, for lack of better terms, if something goes south and we didn't cover in the policy, which is guideline, read this and under.
I read the whole thing multiple times.
But have you explained it to your deputies?
I have.
Did you
I've
hear
sat
this
down
rumor?
with
Did
every
you
single
put
one
that
of
out and go,
them,
no, no, no,
and
go
we
back
go
and read
over
it
it.
yourself?
wouldn't it, I mean, we keep talking about training and incorporating it. Wouldn't it be a better situation when in-service training comes up, if this is such a big issue, and I understand it is, to sit down and say, hey, guys, all right, in-service training this time is gonna be vehicles. Why? Because we got a policy coming out. Just to let you know, this is what the policy's gonna say. Let's start working on training right now, so you guys aren't left in the lurch. Now, listen, this is hindsight, and it's always 2020. But at the same time, you know, that's why we're here. You know, and again, I think that it's, I think training, I think, is important. And there's obviously situations where people are gonna be put in front of cars, and I think that, you know, no one goes out there, law enforcement officers don't go out there thinking, I wanna shoot somebody today. How can I do that? You know, contrary to what, you know, some people, you know, think nowadays, that's not what they do. They go out there and they wanna go home. You know, again, I think.
And I want a policy that's gonna put it in a position where they can go home. And getting in front of a car, and needlessly exposing yourself to that, to where you have to use deadly force. I don't want you reaching in the car window and turning it off, because Joe the meth head is gonna floor it, and you're gonna get drugged down the side of the road. And if you get a shot off, you're probably not even gonna kill him, or you're gonna get killed.
And I'm sure, you know, if you have the opportunity, you sit down with each one of these guys and you explain that to them, and, you know, unfortunately, there's too many guys and not enough time to do it. So, you know, that's why we're here.
Well, but look, the reality situation is that you're not you're not leading the charge on changing the way you effectuate policing in this area. I mean, this is a trend, and it's a nationwide trend, and the reality of the situation, it's a nationwide trend, is because of you know, the way things are being viewed nowadays, and the liability and exposure of any time an officer pulls out their gun, no matter how justified they are, we, and I say we, being both sides of the table, have to justify everything we do. And we're under crazy scrutiny, you know, where everything we do is questioned, everything we do is challenged. And like it or not, there are some areas where we have to change policing. Can't do things the way that we did before. And look, use of force is one of them. You know, the videos that are played, you know, the investigations, the lawsuits, all involve people that turn out to be unarmed getting shot by law enforcement officers.
No, nobody's, I understand, and I want to be clear. I'm not saying we can't change. I'm saying that there has to be a mechanism here that certain things, high liability areas that are done under stressful conditions, where the deputy is going into a mental state that he is reverting to ways he's been brought up in his career, those things are things that have to be learned out of him.
But what I don't understand is you're saying learned in our career. What training did we go through where we were taught to shoot at a moving vehicle?
Well, I think the training is that you stand your ground and you eliminate the threat. And I don't think, it's not that you were trained to shoot at a moving vehicle, it's that you were not trained other ways to avoid that situation. And I think the situation keeps coming up, and I think it's training to do something different. You know, it's.
So for many years, I mean, it has been, you were a deputy sheriff or a police officer, and you didn't back down. And that was the way it was. And in this county, it used to be years ago, you know, chase them into the county because the deputies will blow out the car. And we would stand on the side of the roads, or the guys would stand on the side of the roads, and they'd fire shotgun shells into the car as they drove past. So I'm saying is that there is a level of what's come up over the years that's still ingrained in law enforcement officers that we have to teach out of them.
We used to be able to shoot a fleeing felon. You could report a burglary and the guy was running away, you used to be able to shoot at him.
I agree.
The Supreme Court said you ain't doing that no more, and guess what? That's what the policies came out and said. You cannot shoot at somebody who's running away from you.
And we ingrain that in our people through the training process. Every year when they go out there to training and we go over the use of force policies and drill the policy into their head, we cover those things. What I'm saying is we didn't drill this into their head.
I hear you. We'll start. We'll start. with
Yeah,
in-service
you know,
training.
look, first and foremost, I want to say is that I don't think, you know, I'm maybe speaking for everybody here, but I don't think we're taking what you say as, you know, you sitting there saying, Jeff, you can't change policies, or that you're saying, you know, we're going to dictate. You know, we understand the concerns you're raising, and I think that it's a point well taken that we should, you know, add this to the training. You know, right?
Well, I mean, listen, part of our job as a union is to be, you know, a voice for everyone.
Sure. And
that means we gotta listen to everyone. And we're here because this is what we hear, so. Okay. Jumping down in order, one of the issues we were talking about was access to body-worn cameras, which I think is on page 8. I think one of the issues here was not having access to body-worn cameras in these types of situations. And I don't know, you know, what the intent there is or why.
Can you read that to me?
You're talking about 1.1.41?
Yes. I think it's 1.40.
Okay, what's the issue?
Well, I guess our question is the intent here.
Of all deputies involved shall remain in possession of their body-worn cameras as worn at the time of the incident and uncompromised. Okay? All deputies involved, primary backup witnesses, shall not view any recording on the evidence or computer prior, okay? So that's the issue right there, right?
Which part of it is?
Well, I don't know what he's reading, 1.40. Exception in deadly force incidents that due to the exigent circumstances, such as the deputy is incapacitated or the suspect is at large, access to BWC Am I reading the wrong thing?
No, I don't know.
I don't-
This is
I'm
different
looking
than
at
mine.
One,
9/2017. Oh, you're looking at, so you're looking at the even earlier one.
Oh, okay.
am I reading the right thing or no?
You may be, there was a second revision, I have this, I think the second
Okay.
revision.
What date are you guys looking at, Brody? 2017?
I now have 7/2017. I'm sitting here listening to you. and I'm
Is
going,
that but is that the one you're referring to, or you're referring to?
They were referring to an early one.
I think I was, yeah.
Really, the only thing that was added on there is the exception from the August of 2016 version.
Let me find the one here that is, here, this is it.
You too? Okay. I gotta go offline.
Yeah,